Hello, good afternoon. Thanks to all of you for joining us for this conference call. My name is Chico Chitsike. I'm the Director of Client Development at K&R Gates. Just a quick couple of points. The way that we're going to run the session is a lot of you have sent through questions, which Etienne is going to use as a basis for the call. After the first 30 minutes, the lines will be opened, and you'll all have a chance to ask questions or ask for further clarification. There's a lot to cover, so without any further ado, just like to ask Etienne to take the floor. Etienne, thanks for your time. It's all over to you.
Thank you very much, Chico, and hello, everybody. It's a bit special for me since it is a phone conversation with maybe 80 people at the same time. So we'll cover some questions that you asked in advance to this conference call. And as Chico said, you will receive instructions in 30 minutes to jump in. Any of you will have to press some buttons to jump in and come out from this conference call so that we have a really interactive moment together on the GDPR. I would start first with compliance questions, then I will go through governance questions, DPO, and also some other questions about jurisdictions and the lead authority. If you don't have any establishment within the EU, how can you be fixed somewhere in Europe at one point? Starting with compliance questions. I would start with questions relating to contractual relationship between data controllers, data processors. Just feedback on the controller. The controller determines why and how data is about to be processed, determines the purposes and the means, and the processor acts on behalf and under the instructions of a controller. And the GDPR repeats some obligations that already existed in the 1995 Directive on Data Protection, which is that the controller should execute an agreement with the processor in order to clarify the purpose, the data, the reversibility of data after the end of an agreement, security obligations, confidentiality. All this is listed in Article 28 of the GDPR. And we got some interesting questions on this contractual relationship issue between controllers and processors. One of those questions is how to establish responsibility between the controller and the processor. Nothing in the GDPR defines how you should take consequences on a liability cap in case of a data security breach, etc. So the liability question is a commercial aspect of controller to processor agreements, but it is not designed or required under GDPR. So in case there is no clarity about the sharing or splitting of liabilities in controller to processor agreements, how should you proceed? For me, it's a matter of time. If you have weeks or months to discuss the exclusion of a liability cap in case of a data security breach, so take your time and try to negotiate it with a data processor. In case there is a data breach at a processor, you would ask for the exclusion of any liability cap. This could be a good way to proceed. However, it's a matter of time, and maybe you would succeed in this kind of negotiation with small service providers who would be ready to die for you in case there is no cap of their liability. But you may not obtain this from big service providers who provide you with structuring services. I'm thinking about cloud service provider. They will never accept any exclusion of a liability cap. So maybe the most practical way to proceed is to define collaboration between parties in case of a security breach. Maybe you should include a due diligence security clause so that you could perform an investigation at any time on security questions or confidentiality questions. Should define also collaboration about how to answer a request about the right of access, right to deletion, right to portability. This is something you should agree with your service provider acting as a data processor. But I would not lose time discussing liability questions, because in any case, the regulators will choose who is responsible in case of a breach of this agreement, especially in case of a data security breach, which means that the party acting as a data controller could try to exclude its liability and push this liability on the data processor. It may have no impact on the regulator's decision. So if you consider that your processor should be a new way to have an insurance company, maybe the negotiation with processor would be very tough. In any case, those contractual provisions are not binding for regulators. So if they consider that the breach is under the responsibility of the controller, even if it started from the processors, they will consider that the controller is at least responsible, maybe together with the data processor, but I think it's weird under the GDPR to try to exclude the responsibility of the controller, whatever happens and whatever are the faults or the infringement committed by the data processor. And how should you execute those data processing agreements? One interesting question says, is there any specific formality to execute those agreements under Article 28 of the GDPR? Should it be in written? Can it be online? I would say it should be online. It should be as easy to execute as you can. You don't need a written signature. In fact, if you try to keep reasonable provisions in your data controller to processor agreement, just asking for the minimum obligations to be in place between you and your data processor. Security, confidentiality, comply with the purpose, collaborate on user rights, collaborate on data security breaches, agree on due diligence on IT security questions, collaborate on user information in case you would like to include it. It could be template provisions, and you could just send them to your service providers. If they refuse to sign them, if they refuse to click on a I agree solution, in any case, you would have provided them with some instructions. The best way to proceed is to have a true contractual engagement from your data processor, but it could be digital, it could be online, and if you don't push too far the provisions on liability on your template data processing agreement, you will have easy signature process online, and you will not lose time with that. This is the controller's obligations to have those agreements executed. So I would not suggest that you make this duty too difficult for yourself as a controller. Easy clauses are easily signed. A good way to lose money with the GDPR is to enter into an unlimited period of negotiation time. And I think you don't have time until May 2018. Another way to answer those questions is some questions I was a bit surprised of. Asking, as a data controller, we are updating our contracts, and we will also include new contract language in our employment contracts. It's surprising for me. Your employment contracts with your employees may certainly include confidentiality clauses, non-disclosure agreements, or they may relate to internal rules that create a confidentiality obligation between the employer and the employee. That should be sufficient. Your employee is not a data processor per se. I mean by that, your employee has to, by default, without any GDPR consideration, has to act on your behalf and in your name. So you don't need to copy and paste data processing agreement provisions in your labor agreements. The confidentiality obligation will be sufficient. Your employee is not a third party. Your employee is yourself. So Don't lose time executing data processing agreements between the employer and the employee. This is not relevant. This is not required because you would execute an agreement between you and you, since your employee will in any case be deemed to act on your behalf and represent yourself, even if they can maybe act against your interest. You don't need to modify those labor agreements. The other idea is that if you would amend your labor agreement, it means that each time you would have to modify your data processing agreement with your employee, you would need your employee's signature in many countries. So the more you can avoid having to ask a question or a signature to your employees, the best it will be. Another question relating to HR management issues. We are making changes to our employment contracts to comply with GDPR. Do we need to retrospectively issue new contracts to current employees? Once again, no. Employer-employee relationship should not be affected by the GDPR. Not only for this technical question, since they should not be deemed a processor, in fact, but also because some provisions in the GDPR and some introductory provisions clearly state that employee-related issues would be based on national or local labor code or labor legal frameworks. And those questions are not impacted by the GDPR. So when you can find at a local EU state member state level, you would find a duty to prior consultation of the Works Council, and then after disclose internal policy rules with employees. Those mechanisms are different in each EU member state. They are based on local labor legal framework, and the GDPR does not change at all any piece of relationship and information requirement between an employer and an employee. At least it should not lead to renegotiate any labor agreement. Then I would like to go back to another question about relationships between corporate entities. In B2B relationship and in employee, when you provide B2B services and you can process personal data from the employees of your counterpart, the employees of the corporate entity, which is your client, yes, you are processing personal data. Personal data means any data relating to an individual, whether this individual acts for professional purpose or for purely private purpose. So when you would process your customers' users' personal data, you are processing personal data. You should have a data processing agreement executed between you as a service provider and the corporate entity, which is your client, your customer, in order to define that you would process their employees' data. You would process them as such employee data as a data processor on their behalf for access control purpose, maybe for invoicing purpose or security purpose, and you will not use their employee data for any other purpose. So in B2B relationship, any employee data which goes between a service provider and a client or customer company should address this question of data processing and the purpose for which data will be processed. Let's go now on some other compliance questions about legal grounds. An interesting question is how to prove consent. The question is, we're selling some of our services in agencies where the consumers don't always fill subscription forms. How could we practically get the consumer consent? This is a very good question to start on legal grounds, some clarifications. For a private entity, you will find in the GDPR mainly 3 legal grounds which could be chosen for data processing. One of them is contractual necessity. Under this legal ground, you can process personal data, since it would be necessary and justified in order to provide the services that have been subscribed by the individual about which you are processing personal data, about whom you're processing personal data. It means that under this contractual legal ground, in as much as data processing activity is strictly necessary to provide your services as they have been subscribed by your client, you can process personal data. However, if you would like to use the same data for marketing purposes, in order to promote your services, this promotional activity, marketing activity, is not strictly necessary to execute and to perform your services. In these circumstances, you cannot have this contractual legal ground. You would base data processing on a second legal ground, another one. The second legal ground is the legitimate interest. When you could evidence that or demonstrate that you have a business legitimate interest for the processing of personal data, which would not be strictly necessary for contractual purpose. And if you could justify that you provided proper information to the data subject, they have rights, such as the right to object, for example, right to have access to their data, right of deletion of their data. You also define a data retention policy or a maximum period of use of their data, for example, for marketing purposes. You would also locate data within the EU or outside of the EU under the right contractual clauses you may have with your service providers or with your business partners, with your subcontractors or affiliate companies. This legal ground of the legitimate interest is as valid as the other one, as the contractual ground. The third legal ground would be the consent. Consent is not easy to obtain. Consent is a purely discretionary right. It requires an explicit, informed, freely given, specific expression of will by which someone would accept that you may proceed with the data processing. Therefore, if your business model is strictly based on user consent, this may be the end of your business model, because people may provide you with their consent, and the minute after, they will withdraw their consent. So if you are on a consent-based legal ground, it is very difficult to get contractual relationship, which is another legal ground, or to get a business model which would be sustainable without having those user consent. One main criterion about the validity of the consent is that it has to be freely given. Freely given means there is no counterpart, no detriment, no consequence whether people would provide their consent or would not provide their consent or withdraw their consent. It means that they may have access to a service under a contractual legal basis, and in addition to that, you would like, for example, to promote your goods or services by sending commercial communication. If the sole legal ground you have is the consent, any lack of consent, any withdrawal of consent would prevent you from sending commercial communications or marketing contents. Therefore, this is the last and worst legal ground for data processing. I know that there is a lot of communication under the GDPR saying that these are new rules. Consent would be the core new right for users. Company would have to obtain explicit consent anytime they would like to collect and use data. It has to be specific, and when it is given in a specific way for a specific purpose, it is not right for another purpose. This is not true. All this is not true. Under the GDPR, as under the 1995 directive, we always had various legal grounds, and none of them takes the priority over the others. Consent is not a better way to proceed with data processing before contract or legitimate interest. Those legal grounds have equal value. You have to be in a situation where one of those legal grounds works, but it may not be the consent, and it will not be the consent in many situations. The two main pillars of legal grounds should be contractual relationship or legitimate interest balanced with user rights. And those user rights are not always consent. The third legal ground about the consent is not systematic. I would say this is the last way to proceed with data processing. One clarification should, however, be made. If you want to send marketing communications by email or text message to one of your prospect customers or a customer, in order to promote not your services or products, but to promote third parties' offers and services, in that circumstance, you would need consent because this is the regime for online digital marketing. You should also need consent if you proceed with sensitive data processing. Health data, any information relating to race, ethnicity, political belief, religion, etc., is subject to prior consent of the user, which is also a discretionary right. But if it's not for online marketing purpose, or if you don't proceed with sensitive data collection or use, consent is not a user right. Consent would be a legal ground, and this would be the last of the legal grounds you should claim to use in order to justify data processing. Let's go now on some other questions which could be related to those questions. When it deals with employee data, an interesting question was under which condition a company could access the email of a former employee for business reasons, knowing that no prior consent has been given by him before leaving the company. Complex question, but you may have a simple solution. When your employee is about to leave the company, you usually have to pay him for the last wages. He could sign a document saying that this employee took any remaining personal information he may have stored in his professional computer or professional device. Under the verification of your IT teams, you would enable a departing employee, to take his personal stuff. It may be pictures, documents, videos, whatever this employee has stored for personal purpose. Subject to verification from your IT teams, you would have this employee leaving the company, and therefore you create the assumption that any remaining data is professional without any doubt, since you would have created this termination process. So it's just a matter of departure process and not a matter of employee consent. Let's go also on sensitive data processing, which could be health data relating to your employee or to your clients if you are in the medical industry or health sector. And we have there an interesting question, which is, does the processor need explicit consent from the data subject when processing sensitive data on behalf of the controller, or would you recommend it? The obligation to collect the consent of someone because you would process sensitive data bears on the controller's shoulder. He may delegate this obligation to inform people about sensitive data processing and to collect their consent, but in any case, if the processor does it and provides information and collects the consent, the processor will always do that on behalf, under the instructions, and in the name of the controller. So sensitive data processing and consent collection is a controller's obligation. It can be outsourced to the processor, but it is still a legal requirement for the data controller. We can still go on legal grounds then in B2B relationship, and I see the clock in 3 minutes. You will jump in this first monologue so that we can finally interact all together on some other questions, or if you want to go back on the first question I did address with you. So let's finish this solo, I would say, with legal grounds and B2B relationship. The question is, we are interviewing client employees. We collect personal data of those employees. Are we required to get consent from each individual person we are interviewing? No, you don't need the consent, because if you interview those employees of your customers, it is because you are providing your services, which would be to collect data from those employees. So you should include in your contractual relationship between you and your corporate customer a provision saying that any personal data of your customers' employees that you could process during the performance of your services is subject to GDPR, right of access, retention policies, information, etc., which should be provided by the employer, I mean your customer, to his or her, to his employee, to its employees. Because if you provide a direct information to your customers' employees, they may want to exercise directly with you a right to object or the right to have their data deleted, which is not the essence of the relationship you have with those employees. You collect their data because they are employees of your customer, and their rights could be exercised, but through your customer and not directly with you. If this is the case, if you would like to welcome any employee request and proceed with it, you should organize this in your contractual relationship with your customers. And I think we are about to be at 30. I was about to start with governance questions relating to the data protection officer. I will just maybe take one of those questions, which is the DPO mandatory or optional? How do companies determine whether they would have to appoint a DPO or not? GDPR provides some criteria, but what is considered large-scale processing? Which criteria should we use? First, if you don't appoint a data protection officer, you will have to justify that you didn't have to. Second, if you don't appoint a data protection officer, it means that nobody internally or externally is coordinating your data protection compliance program. You have people in charge of drafting inventories, people in charge of drafting privacy impact assessment, but you would not have any data protection officer in charge of coordinating this, advising on compliance, and distributing policies, raising awareness. So the answer to this question and to another question we had, even if it's not mandatory, should we appoint a data protection officer? My answer is yes. If you don't do that, you have an orchestra without any chief. You would have a project without any project manager. So having to appoint a data protection officer or being in a situation where this is optional is for me exactly the same, since your obligations will be exactly the same. Drafting an inventory, draft privacy impact assessments, define retention policies, monitor your contractual relationship with your service providers. All those requirements are strictly the same whether or not you are appointing a DPO. So the choice is not a choice. If you lose time justifying why you don't appoint any data protection officer, it will be checked by regulators. if you appoint someone, at least you facilitate your coordination issues about compliance programs. I think we are ready to start with your real-time questions. So maybe could we provide our audience with some instructions on how to proceed?
Sure thing, sir. Ladies and gentlemen, if you wish to speak during the conference, you may now unmute your line by pressing 6-6 and mute your line by pressing 6-3. Thank you.
So 6-6 to jump in, 6-3 to come back to a mute regime. Is there any first question?
Yes, I have a question on the language of the data processing register. I understand that there is a recent decision, not decision, but statement of the Bavarian data protection authorities that they request the register to be available in German. Will other DPAs join this kind of approach? Because for a multinational to have it translated in all languages, it becomes a very heavy burden.
Mm-hmm. So welcome in Europe. Since we have several languages, and because this GDPR mechanism still provides member states with some flexibility, we have 53 provisions of the GDPR. Some of them are procedural, some of them are about user rights, but we will have, and we already have many updating process of local legislation. Next week, we may have a new French law. Last year, Germany had some new provisions. The UK is in the process of updating its legislation for GDPR. Not because GDPR would be a directive. The member states don't need any implementation tool, but because existing legislation has to be coordinated, at least on procedures, with the GDPR principles and definitions. You have the main establishment solution. If you are a multinational company having a headquarters outside of the EU or within the EU, but having many establishments within the EU in various EU countries, in several EU countries, you should designate a main establishment where you will have to concentrate and consolidate your data processing registers. If it's in Bavaria, it should be in German. If it's in another lender of Germany, or if it's in Italy, UK, France, etc., you may have to apply the other language required in this other country. So by the main establishment one-stop shop mechanism provided by GDPR, you would be able to avoid having to translate your registers and to synchronize your registers in several languages. So I hope that member states will not use this language issue to create difficulties for companies, but I would suggest English to be the by default language when you are in several countries. And if you need real-time translation upon request from a regulator, maybe you should wait for this kind of request to happen and then translate into German if you are still located, having your main establishment in Bavaria. Would we have any other question?
Hi, Etienne. So I have a question. One is more in relation to clarification on what you said earlier regarding to marketing materials and sending emails. So I'm glad that you clarified the piece that we don't actually have to rely on consent, that there are other legal grounds. But then you ended with highlighting one point in relation to marketing to prospect customers, which would require consent. I just wanted you to clarify that the reason why you would need a consent there is because you don't currently do any business, or therefore you don't have a contractual necessity, neither legitimate interest to send those marketing materials. Would that be the reason?
So the reason is that this question is not governed by GDPR. The marketing, the online or electronic marketing by text message or by email is regulated by the e-privacy directive, Directive 2002/58, which has been updated in 2009 by the Directive 2009/136. This directive, this e-privacy directive on data protection and privacy in electronic communications, governs localization data, IP address, traffic data processing, email marketing, text message marketing, or what also they will call metadata relating to network traffic. Those questions relating to electronic communications are not under the GDPR scope. There is a current legislative process in order to amend or transform the e-privacy directive in order to create a future e-privacy regulation. This regulation is under debate. It may not be adopted before the end of 2018. It may not be enforced before the beginning of 2020. In the meantime, on May 25th, we have this GDPR enforcement date. But at Article 95 of the GDPR, plus whereas 173 of the GDPR, you have a very explicit provision saying that GDPR does not have any impact on the e-privacy directive for questions dealing with the same matters. What are those questions coordinated between GDPR and the e-privacy directive? Mainly, this is the definition of consent, which means the criteria defining what is a valid consent, free of charge, freely given, explicit, informed, etc. And if you go in the definition provided by the GDPR of what is consent, this definition from the GDPR is exactly the same as the one we had before in the 1995 directive. Therefore, since the concept of consent was not amended by GDPR from the 1995 directive, and since the GDPR says it has no impact on the e-privacy directive, it means that online marketing, localization data, traffic data processing are still governed by the e-privacy directive until it will be amended in 2020 by a new e-privacy regulation. So no change at all on your commercial practices. One other topic which is not modified by the GDPR on May 25th, coming from the e-privacy directive and the future regulation, is cookies. All those tracks used for digital advertising, authentication of a user, etc., a very, very important piece of identifiers. They are governed by the e-privacy directive, so May 25th will not change anything on those questions. Any other question?
Good afternoon, ATM. May I ask you a question about responsibility for ensuring that a data protection or data processing, rather, agreement should be in place? I'm aware under the previous directive that responsibility fell squarely on the controller, but GDPR seems to be silent as to that point. Can you give any guidance, please?
I would strongly suggest, instead of defining liability caps or excluding liability caps, to proceed with your data processing agreement with the insurance mechanism provided by the insurance company of your data processor, plus your own insurance company. This is the best way to secure data breaches, include coverage of your reputation, coverage of interruption of your services, the loss of data, etc. So for me, insurance is the new non-legal but contractual solution for the question of liability between controllers and processor, because you will never or almost never be able to negotiate a 4% liability cap on the side of your processor. It's true that there is nothing clear in the GDPR. However, the market takes the lead on this front, and for cybersecurity risks or liability risk under the GDPR, I'm not working for insurance companies, and this is absolutely not our practice at Kennel Gates historically. However, I would strongly advise to have an insurance solution instead of a purely contractual solution with your processors. Any other question?
Yes. Can you hear me?
Yes, very well. Hello.
This is a question about model clauses and multinational groups. And the question is, let's assume the entity is multinational in all regions of the globe. Not a large company, though, and has model clauses in place, model contract clauses in place with respect to data protection for each of the entities, including the European entity. And the question is, with respect to employee data, the entity has a global information system, if you will. It has a global cloud-based
HR management, security, and control of access, etc.
So if you have those model contract clauses in space, is there anything you have to do with respect to segregating EU data? Or, assuming those agreements are in place, are you okay to share and use the cloud-based system?
You will be okay, as you would be under the existing 1995 directive. You will still be okay under GDPR with those model clauses. They are a bit expensive to track. I mean, if you have many data flows with many companies, you may have an exponential number of model clauses to execute within your group. But if it is in place, nothing changes. Those model clauses will still be valid until they are modified for everybody, but there is no reason why it would happen. If you would be under the privacy shield for your EU to US data transfers, it will still be fine. And if you want maybe to be in a sustainable situation without having to manage tens and tens of model clauses agreements within your multinational group, I would strongly recommend you enter into binding corporate rules process, because it not only addresses data transfers, it addresses also data protection and compliance. It is also expandable not only within the EU and non-EU companies, but it is recognized also in APAC region as a good standard that would work also with China, Japan, Singapore, Malaysia, Philippines, etc. And it could also be a good way to transfer data, but also have a copy locally in Russia, as you may have to do it in China. So BCRs is a bit luxurious way to proceed, but when you will be tired of managing agreements between your subsidiaries, maybe you could enter into a BCR process. Today, nothing changed.
Okay, very good. And one follow-up question. Is the answer the same with respect to sensitive data?
Yes.
Okay.
There is no broader definition of sensitive data, the same as before. A collection of such data is subject to individuals' consent, and then processing of such data, transfer, storing, sharing, whatever, is subject to normal rules. The first key rule for sensitive data is collection with a specific information, but then after, such data is as any other. You will still have, in any case, to secure such data as any other. So no difference.
Very good. Thank you.
Another question?
Can you hear me?
Yes, well.
Yes. Fantastic. Under the GDPR, the data processor has to notify the controller in case of a personal data breach without an undue delay. Could the data processor and the data controller contractually define the timeline in which the data processor needs to notify the data controller and then, create some kind of liquidated damage. So like an SLA. So by a given date, if you don't do that, you should pay such amount in place of, letting the parties, assessing the liability, damage, and then entering into this complex matter. So could we create that system? Is that sort of recommendable and then viable?
It is viable. I would say it's an add-on which was not provided by the GDPR, and this lack of clarity is an issue, in fact. Today we have the UK Information Commissioner suggesting that a data processor should immediately report a data security breach to the controller so that the controller may notify, in case it is requested, to the Data Protection Authority within the 72 hours period provided by GDPR. So there was a question which was, if the processor discovers a breach, does the processor have 72 hours and then notifies the breach to the controller, which would have another 72 hours delay? And regulators did not agree on this question. So today, the doctrine is the dominant doctrine or market practice would be you should put pressure on your processor, having to inform you immediately upon discovery of a breach, and then you would have the remaining time of 72 hours. It has not been clarified. Therefore, if you can create security and clarification in your agreement, it will be better. And in terms of SLA, yes, it's a good way to proceed because it's better to have incentives instead of sanctions. So it's a way to manage it. But please have in mind that between November 2017 approximately and June 2018, tens of thousands of agreements in a kind of a nuclear war of contractual relationships are going to be executed. So the question is, how long do you have to negotiate?
Yeah, very smart indeed. Thank you.
Thank you. Next question, please.
Hello, can you understand me? Hello?
Yes, we can hear you very well.
Okay, super. So I have a question. In the beginning, you said something that employer-employee relationship doesn't really fall, if it falls under labor agreement law, the GDPR doesn't apply. So we are a startup active in HR tech, and for example, we facilitate the passing on of a medical certificate from the doctor to the employer. Is this something that would fall under GDPR because it falls under labor agreement law, basically?
So your activity would have a legal grant, which would be a legal obligation to transfer this information from A to B. And the way you would perform this, you would execute this legal obligation, would fall under the GDPR. Therefore, there will be no discussion on the legal ground. It's required by law. But there could be a discussion on how you proceed, which means, do you only collect necessary data and no additional information? What would be the retention period you would put in place from the moment you collect data? Will you give back such information to your client because you would be deemed acting as a data processor? What is your role? Do you consider yourself as a processor or as a controller? So all those questions are still managed under GDPR, even if your activity is strictly governed by a legal requirement.
Okay, perfect. Thank you very much.
You're welcome.
Hello, can you hear me?
Yes, very well.
Oh, thank you. Quick question about DPOs. What about the organization? Does GDPR have anything against having a kind of EU or global DPO? And country-based DPOs?
This is the best way to proceed. DPO is not Da Vinci. He cannot know everything from the top to the bottom of the company. So this DPO will need relays, proxies, and some correspondence. Those correspondence could be deemed being local DPOs or just correspondence. The thing is that a DPO is not only a title. A DPO has to be registered with a regulator. So I would strongly suggest that you register each local or a global DPO with one single regulator where you would have your main establishment in Europe, and replicate the designation of your local DPOs to the local regulator, but having one regulator concentrating the vision and understanding of your structure. And you can be as flexible as you want. Your DPO may be based in India and being a DPO for your 29 subsidiaries within the EU. So the location of the DPO, the organization of the DPO across the group with sub-DPOs or with just correspondence is completely open and free. You can use one DPO for all groups or have a kind of pyramidal mechanism as you described. But I would strongly suggest that you all register them with one data protection authority in order to avoid being in a situation where you designated one main establishment and in the same time you would be in an inconsistent situation where you have appointed local DPOs with many local data protection authorities who would feel that they can be free to consider that they have a full jurisdiction on your situation, which should not be the case. So the best way is to be very clear and concentrate designation in one place, even if after we have local DPOs in many places.
Thank you very much.
You're welcome. Another question?
So I think just following up on what you just said regarding the DPO, if in the company you designate a person that would be leading the GDPR compliance program, monitoring and ensuring the data mapping, all the activities you mentioned, but the person is not actually called DPO, but for instance has a different name like GDPR compliance leader, would that then be seen by the authorities as someone, as the company having a DPO, or do we need to have an actual official title? The reason why we did that is because we also did not want to 100% follow the responsibilities that the DPO needs to have. So we do have someone running the program, but it's just not called DPO. So I was wondering if there are any potential consequences coming from that.
So you are free to do whatever you need and whatever you want. You will have one registered person being the sole and unique DPO. And the other person would be a project manager, whatever is the title of this person. This is your way to organize efficiency and your compliance program. And there is no rule against that within the GDPR.
Okay, thank you.
You're welcome. We have 4 minutes left, so let's go on. Hello? Any other question?
Is there value to have a DPO per country in place of one DPO for all of Europe?
In order to stick to local reality, maybe, but maybe not through having a DPO per country appointed, but someone being a correspondent and not officially a DPO. It depends on your resources, in fact. But I assume your question is based on what is our interest. Maybe your interest is not to multiply exposure to many jurisdictions where you would have a data protection authority being deemed having jurisdiction over your activities because you registered a DPO. So your country of registration of your scheme of DPO is more important than the localization of your DPOs or your correspondence. Maybe your interest will always be to attract any issue at your main establishment within the EU in order to avoid multi-jurisdictions, to avoid loss of time, repetition of questions, and always having to justify your compliance scheme or governance scheme. In major group of companies where you have, I don't know, let's figure out a situation. Multinational company having 150,000 employees, 20 establishments within the EU, or 80 within 20 European countries, you will have maybe 70 to 100 person on board. Not all of them should be DPOs. One main coordinator could be DPO and have some relays and proxies without having to appoint them officially as local DPOs. There is no need unless you feel that people will truly engage in their role because they would be registered with the Data Protection Authority. Therefore, I would just suggest one regulator to be in order to register all your DPOs. Once again. Another question?
Perhaps one more if you have a minute.
Yes.
If a company is doing due diligence in the context of, let's say, an investment or an acquisition on a third party, and that third party is subject, is in the EU, let's say, or EU nationals or whatever it is. How do you get the consent to do the due diligence? Because obviously you don't want to disclose that you're doing the due diligence.
This is a tricky one, but very interesting, especially for a law firm, because if I wouldn't have the answer to your question, we would have an issue as a law firm practicing in the M&A sector. So you don't need the consent, because the legal ground of the data processing that will be performed during the due diligence process is not the user consent. It would be impossible to collect and to obtain. It is your legitimate interest as a business entity to perform a due diligence process when you would like to purchase another entity, and therefore, for legal reasons of due diligence, having to collect personal data from the targeted company. So legal ground is legitimate interest. It could not be contractual necessity because you don't have any direct relationship with the employees of your other entity. Then you may use accountants, law firms, service providers, etc. All those people will act on behalf and for the purpose of your due diligence process. Therefore, it defines the purpose, the retention period, the recipients that could be entitled to have access to such data on the need-to-know basis. You will be fine, nothing changes, and you have a strict scope of data processing for the purpose of your M&A preparation, of your transaction preparation. After the end of this due diligence process, you may justify retaining data for maybe a statute of limitation period that you should find somewhere between the law of the country where you are established or the law of the country where your target company is established. But please never rely on consent.
Understood. And do they have a right to know effectively? Do you have a duty to disclose what you've discovered?
No. Not more than for any other corporate transaction preparation. They have to know when the law provides that they have to know. But this activity is already covered by GDPR to say that when there is a legal necessity, it's under privilege, etc., for a limited purpose, for those questions, you don't have any information requirement unless the law provides for it, but not the data protection law, but maybe corporate law or employment law. Nothing changes, and I would say it's business as usual.
Excellent. Thank you very much for your answers. Very clear. Appreciate it. Thank you.
Thank you very much. I'm afraid this was the last one. The last one by phone, but if you have any follow-up questions, we'll do our best to concentrate some answers to provide you with some additional assistance. And Chico, I think we are around the end of it, and Carlos too.
Yeah. Can you hear me?
Yes, very well.
Hello. Great. So Etienne, thanks a lot. I hope everyone found that useful. And indeed,
I hope so too.
Of course, we didn't have a chance to cover all the questions, but we'll most definitely follow up and provide you with Etienne's details and allow you to follow up on anything more specific. So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call. Have a nice day, everybody. So thanks a lot for your time. Very much appreciate you joining us for the call. Have a nice day, everybody. So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.
So thanks a lot for your time. Very much appreciate you joining us for the call.
Have a nice day, everybody.